Hey everyone, it's Rob Ryder. Today is Sunday, July 23rd, 2017. Let's claim the name to be the owner because legal fictions need a master. And what the judge said. Again, it's Sunday, July 23rd, 2017. All things have names. Most things have unknown owners. Well, that'd be according to Rob Ryder. Let's see if we see that to be correct. Rob Ryder. My email address is courtofrecord@aol.com. That's courtofrecord@aol.com. No S's on the court or no S's on our record. And the AOL.com. And my phone is 616-712-6179. And I have to ask, if you can, please donate while we're working towards a remedy. Still don't have one. And, I have to eat, pay a few bills. So if you can help so I can continue on, I'm eternally grateful. The PayPal account is my daughter's name, her email address, ashleyrytlewski@gmail.com. That's ASHLEYRYTLEWSKI@gmail.com. Or the snail mail, Robert Rytlewski. That's RYTLEWSKI. 10955 14 Mile Road Northeast, Rockford, Michigan 49341. Anything you can do is greatly appreciated. Cash, check, money order, PayPal. Thank you very much. Okay, so the thing about the judges doesn't really fit in with the rest of the story immediately. But let's just see what judges said this week, because I got lots of things going on. I got fingers and everything. And here recently, it's been mainly figuring out what to put into the court to get the court to pay attention to us. And so we'll talk about what those things are exactly. But here's some things that were said this week from a bankruptcy judge. When asked, "How do I have my documents seen by you?" he said, you give your documents to the recorder, clerk, in open court, who will give them to me. But whatever you give to the clerk to give to me, make sure it says what it is you want the court to do. You can give them to her here, open court, or mail them to her. Don't just file them in the clerk's office. I won't see them. And if you have a problem with an attorney in my court, bring it to me. Well, that's huge to know, because any attorney in any court isn't using the name that's on his license to practice in court. What Linda, who had this talk with the bankruptcy judge, had found out, she had called the Michigan Supreme Court and asked about the role of attorney for the attorney. And they said, yeah, he's in there, and they gave his full legal name, right? First name, middle name, last name. But as it turns out, when you practice in federal court, you have to actually fill out another application with them. And on that application, he only used his middle initial. Yet in the paperwork, he has to say where else he's authorized to practice at. And so in one place, he's using his full legal name, and the other place, he's using the name with a middle initial. Well, I'm saying that one of those is a fraudulent identity, and we should bring it to somebody's attention. And so that's what we were trying to do, was we were going to put a motion in to show cause why the attorney shouldn't be found in contempt of court for bringing his action in an improper venue, using a fictitious name, using a incomplete or improper process, yada, yada, yada. And because of that, discharge this case and give me back my property, right? State the claim upon which relief can be granted, and then ask for the relief. Well, after the judge had said this, Linda said, okay, well, I'm not going to put the paper in today. I know how to do it. Let me talk to Rob again, and we'll do it and put it in next week, which is this coming week. And so after this video, I'll doctor up whatever it is I think she should put into the clerk recorder and give it to them. And I might have to wait and explain all that about the clerk recorder and so forth in more detail in an upcoming video. But the person I'm talking about is if you're in open court, there's somebody sitting by the judge. Now, they may not be there recording because it's being recorded electronically, but they will still record your exhibits into the record to show that they've been put into the court instead of into the clerk's office. Because when they go to the clerk's file cabinet, that is where they stay. They're filed in the clerk's office. They're not in the court record. And anything you're putting in, you want to be an exhibit of evidence. And so an affidavit, let's just think about this now. An affidavit, you're going to go swear to it. Well, now it's a sworn statement. It's evidence. It's self-authenticating evidence if you've had it done by the notary where they put their seal on it. It's not hearsay, right? So it's testimony. It's like a deposition. Well, you would give your deposition to a recorder. Well, as it turns out, notary publics can take depositions or can sign an oath on a deposition. So it's who you give your paperwork to first that we're doing incorrectly. We're taking it and putting it in the clerk's window when we need to find the evidence clerk or the exhibit clerk or the recorder or the clerk of court or whatever name they're using in your court that you're dealing with, that is the person that takes exhibits, depositions, to put into the court record. Because until it's in the court record, it doesn't matter that it's in the clerk's file. It's not in the court record. And hey, if you have a problem with an attorney in somebody's court, bring it to them. And I'll show you another example of that here in just a second. So that's what we'll be doing. Now, our second one was a divorce judge who said, "You will answer this. I'm setting a hearing for 7/31/2017. Hey, that would be like, in less than 10 days. And who did he say it to? Well, he said it to attorney for plaintiff as part of conversation between the judge, the attorney, and the witness, which some people call the defendant, but we don't, right? He's the witness, regarding a motion filed by a witness asking for an order discharging the matter due to plaintiff's attorney prosecuting in an improper venue under a false identification using unauthorized process and pleadings. Now, I don't remember if that's what the gentleman put in, but he did bring up the thing about improper venue. And so he had filed this motion with the clerk, but he had brought it into the court, right? He had a copy with him to give to the attorney, to give to the judge, yada yada. Not necessarily going to the clerk, but had copies to give the attorney, give to the judge. That's how he thought he should do it. Well, they're having a conversation, and he says, "Judge, I'd like to enter this document into the court record." And he handed it to the prosecutor, or not the prosecutor, the plaintiff's attorney. He's actually the prosecutor. He's prosecuting the case. Who started to read it. And he said, "Oh, well," he said, "he's already argued jurisdiction before, and you've dismissed it, or you've not dismissed it, denied it." And so the judge said, "Well, let me see that." And so the attorney, right, who had just been served, basically, the judge is sitting there. Now think about this. The judge is sitting there. He sees this guy hand it to the attorney. The attorney reads it in open court, not the whole thing, but he's speaking. And the judge says, "Well, let me see it." And he hands it to the judge. Okay, well, the judge reads it and says, "Hey, you'll answer this. I'm setting a hearing for 7/31/2017. Because the judge, if it's up to him, right? If he can have a hearing on it. But if you want him to see it to make sure something happens, you need to go give it an exhibit. But he can say he saw it whenever he decides to. Because it was given to him by the plaintiff. So, it was like everybody was served the same document. I don't know if that was his intention, but if you just look at how it was. Well, that's how it worked out. The man personally served the opposing party in open court. The judge sees it, says, let me have a copy. So now he has it that he got from the attorney, and he says, well, we'll have a hearing on this. You will answer. And in there, it's being claimed that the case should be discharged because the attorney is using an improper name and an improper venue. So that'll be an interesting day. And a traffic judge said, right, now this is case 3. Now, this one didn't just happen, but I just was told the story, so it gets fit in. The traffic judge says, can you pay a $20 administration fee? Well, who did he say it to? Well, he said it to a name claimer. After having reviewed a legal document, name claimer had asked him to review. Having completed his review, he stood up from his judge's seat, did a little jig, returned to his judge's seat, uttered his statement, can you pay a $20 administration fee? Upon which, being accepted by the name claimer, yeah, I can do that, evoked from the judge a phrase not often heard. Case dismissed. Kink. He told the guy to go upstairs and to this office, and they'd call his name in a minute. And yeah. So the legal document that the name claimer showed the judge, who's after looking at it, looking at the man, looking at the paper again, pushed his chair back, stood up, did a little jig, sat back down in his judge's seat, looked at the man and said, well, can you pay a $20 administration fee? And the guy said yes. Now, he could have said, no, I can't do that, Judge. I believe that the prosecutor's in contempt of court for bringing this action in an improper venue, using a fictitious name, blah, 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 blah. And I believe the judge just said, well, he's in contempt of court. Because doing that little jig, when he pushed the chair back, did his jig, sat back down. I don't actually know what he did. Wasn't really explained that well. It doesn't matter. He did something. I mean, nobody ever, the guy had never seen it before. What's the dude doing? He thought he was headed out the door or something. I believe he changed the venue, right? He put on his different outfit, whatever we want to call it. Talmudic law, he went from one side of the books to the other, and it requires some little ceremony. And that was the courtroom ceremony. Okay, and then a supervising judge said, who? Well, the supervising judge, I will investigate the issues raised in your letter and respond to you. That was written on bond paper under the seal of her court. And we'll look at what brought that all about. But again, I was bringing up the fact that it's an attorney using a fictitious name in a courtroom. Right? Now, this judge had just said, right, if you have a problem with attorney in my court, bring it to me. And while the supervising attorney or supervising judge isn't necessarily the judge of the case, they are the judge of the court, right? She's the supervising judge of a particular court building or set of courts, or whatever, however you want to phrase it. She has administrative control. So if you were to so my point is, if you were to write something and just give it to the judge of your case, nothing happens, well, see who his boss is, because everybody has a boss, right? Who's the supervisor? Look who has administrative control over what's happening in that court. And that would include when you don't get what you want from the clerk. Everybody in that court building is working for the supervising judge, right? They're in charge. They're the principal, superintendent. Okay, what else happened? Well, now we're done with judges. Let's see what a clerk said. The clerk said, well, we don't give a receipt for payments by check. The clerk said that to a man who was calling to find out why the day before he had not received a receipt that evidenced he had paid the $50 motion fee. He was told he had to pay to have his motion seen by the judge because he wanted to file a motion into his case to say, guess what? The attorney's using a fictitious name. He's brought it into an improper venue. We want to have this case discharged and return me my property. Well, they said, so, we called and they said, well, you got to put it come down and pay a $50 motion fee and put it into this certain office, which he didn't do himself, but he had done because he couldn't leave. And they took his money and they did whatever, but they didn't give him a receipt to say what he had spent the $50 on. And I'm not sure who the receipt or who the check was made out to. I had to find it out because now I know who it should be. I didn't know at the time who it should have been made out to. But as you can see, just because you go and pay the $50, if you don't have a receipt that shows what you paid it for, then how are you ever going to say, well, I paid to have a motion put in, Judge? How come you haven't seen it? Subsequently, though, because he did call and complain and was diligent about it, the clerk is now refunding the payment and providing instructions on how to file a motion in a foreclosure case before a judge. And we'll take a look at that, and that's like, well, there you go. That's what we need. Where is this book at that this came out of? So very interesting things are going on, right? So let's claim the name to be the owner. We're going to find out there's many legal fictions that you're the owner of. You haven't ever claimed their name. Let's see what that's about. Okay, and I wanted to point out what's going on here? I want to show this thing is exceedingly slow. All right, hang on a second. Okay, I wasn't quite able to do what I wanted. There's something wrong with YouTube right now, and I can't show you. I wanted to show you what video to go to see where some of the details are that I would be talking about, which was that shows that the borrower on a deed of trust or mortgage is actually the beneficial owner of the investment contract that the thing really is, because they never lent you any money. So, but I can't do that right now. So what I'm going to do is I'll try to put that in a link, right? But anyways, let's just move on. Move on. Okay, so why are we here? How about this? Let's go look at Gabe. So Gabe was the guy that the judge he handed the judge a piece of paper. And what he gave him was this right here, which is a fictitious business name statement, San Diego County, California, Lazario Gabriel Angulo, and his name and address. And so what he did was, well, he claimed his name, Lazario Gabriel Angulo. That simple. Where it's located, registering information, well, that would be him, right? So who's the owner of the name? He put himself as the owner. Signed it. In California, it says to publish it. So you know what Gabe did? He followed the rules, did what it said to do. I mean, this is all done by a law. And this was the statement, right? All caps, where it's located, is hereby registered to the following owners. Him and his proper name. The business is conducted by an individual. Right? You had to be in for 3 weeks, September 8th, 15th, 29th. He did 4 weeks. There you go. Hard to say he hadn't given proper notice. And so when the judge is looking at this, he said, whoa, this dude owns the name. We're not going to be able to tap that account. Right? Because this is your all caps is tied to your Social Security account. Or I should say your Social Security account is tied to your all caps. Your all caps is your estate. Your Social Security account is an account of your estate. In either case, you and your proper full legal name are its owner. But what I did notice on this, see, this has physical business address. And see how they have county in? They are putting your property in a different jurisdiction than you, because they don't ask you for your physical address, right? There's no place to put the county. And so I guess if I was going to do this because there's room, I'd put in here San Diego County. Not that the judge didn't pay attention to it, but there you go. So, and so if you've never seen this before, if you look on your state website or you just Google your state, name of the state, fictitious business name, or doing business as, or whatever it is, there's some kind of little thing you need to do that you haven't done. And I'll show you where it says in the Michigan law, even if the style of the name is different, you're supposed to do this. So the fact that one is in all caps and the other one's in proper case means they're in different styles. And so you would have to do one. All right, so this isn't that difficult to do, right? One page thing. I spent a lot of time on it right now, but the dude followed the rules for his state. And he put his all caps name here. And then he put his proper case name here. Now, a lot of people, because I talked about this years ago, and in fact, I've never actually done it because they wouldn't let me do it the way I wanted to. And it wasn't so much the way the name was, it was because I couldn't pay the fees the way the fees said to be paid. It's like, well, this isn't right. That isn't what the law says. Now, this was 5 years ago, and I'm just kind of learning this stuff like everybody else, right? So I'm not going to do this. But other people did, and some of them got it through, and other ones didn't. What they complain about isn't so much that you have your name here, it's that you don't have any addition to your name. And so if you were going to have to do an addition to your name, I might put comma estate, because that's what it is. Your all capital letter name is an estate. Or maybe I'd put it with semicolon estate. Then it's really not part of it. It satisfies them, but the name is everything on the left of the semicolon, not necessarily what's on the right of the semicolon. Or a comma, could be like a continuation in the name or a hyphen, and that's the thing about this that we're talking about is the clever ones that run this system, right? They're using grammar as a weapon, where capitalization matters and proper names matter and proper addresses matter. Commas matter, semicolons matter, quotes matter, parentheses matter, boxes matter, right? This is all things to do with grammar. County of Kent, Kent County, right? Switching the order of words matters because everything has a name, one full legal name, what is to be known as in legal matters. It may have lots of nicknames, but only has one legal name. And yours is your first name, middle name, last name. Although maybe we shouldn't call your middle name. Maybe we should say your given name and your last name, or your Christian name and your surname, or whatever you want to call it. Where there is no middle name, you just put them both as your first name. And in fact, I do that in any form I see where it's asking for a middle initial instead of leaving a place for the middle name. I always put Robert Allen. Anything I'm doing, I don't care if it says do it backwards, whatever, unless the boxes are there specifically backwards. But otherwise, if it says name, I would put it in. I'm always going to put my name, my full legal name. Even if they have in parentheses, hey, we want you to put your last name, first name, middle initial. Cross that out and put your name the way it's supposed to be. You only have one name. Okay, so this is what Gabe gave to the judge and got to do a little dance, and all of a sudden a ticket that should have been for a couple $100, right, some moving violation, was a $20 administration fee. To which, again, I think Gabe could have said, no, I don't want to pay anything. Right? I want you to find this man in contempt of court for bringing this action in an improper venue. And see what the judge says. Because once you claim it's an improper venue, then the judge has to make a legal determination. You don't have to prove it's what the venue is. You just need to, judge, I just need to say, from my understanding, I just need to tell you, I believe this is an improper venue. And now the prosecutor, plaintiff's attorney, or record, whatever you want to call them, has to prove it's in the proper venue. just like the guy that needs to come back on the 31st and prove that he's in the proper venue. And this is after they had already, this is the thing, in that case, they had already denied his motion for improper jurisdiction. And I can't make it any clearer. You need to say venue before jurisdiction, because the venue determines the jurisdiction. Okay, let's go on. So that was that. But when Gabe had sent me his papers, he sent me, because this had actually happened, where was that? Here it is. So when did this happen? This is the ticket that goes to that thing. Rotate, rotate, rotate. San Diego Superior Court. Angelo Lazario. Right? So this isn't a ticket. What this is actually a minute order. But, this is what the judge is filling up at his desk. Pay fine, $20. And I wanted to show you what it was. If you want to look it up, it's California Vehicle Code VC 21461A. VC 21461A. Which is like disobeying a traffic sign or traffic sign, I guess it was. And so I Googled it last night. I don't remember what it is, but there was a site that showed, what's the ticket cost, and it was like, I don't know, $230 or something like that. But no, he paid 20, and total amount due $20 on or before 1/10/17. Well, he had told Gabe, go upstairs to this room and they'll call you up to the window or whatever. So he did, and when he got there, he paid him the $20. And this was his receipt. Well, on a convolute, court trial minute order. All right, and this guy was just a temporary judge, but he still did the dance. Because judges are more than just attorneys. I think most judges, they come from families of judges, right? You put in certain names of judges, judge whatever, and you find a whole lineage of these people. It's like, they don't just, not anybody becomes a judge. I think they learn this stuff from childhood. How else are you going to control the sheeple? Okay, let's continue on. So that's what that court case was about. But what he had sent me was that he was going through a foreclosure and had gotten some papers. And while there were numerous papers, one that were of interest to me were these things that were called full reconveyances. And this is simple, because he had told me the story about the thing in court and doing the fictitious name, and I said, well, send me what you did. I want to see what you did, because other people say they can't get them to do it. I want to show it in a video. And so then I did that, and he sent me these, and I'm looking at these papers that go to a, real estate transaction. And he has full reconveyances that show that it's already been paid. Now, if you've never seen one of these before, it could be called a full reconveyance. It could be called the satisfaction of mortgage. It could be called mortgage discharge. They have different names in different states. Not everybody has found these in their property files, but other people have, like Gabe, like people in Florida have, right? And people all over. And if you've ever refinanced, you'll find one in your property file for the mortgage that was before the one that you have now, right? Because they're going to make it pay it off or whatever. That's how I had found mine back in the day. I think mine were called discharges. But what they're doing, see, they don't put it in your name. They put it in the name of a legal fiction that looks like your name. So somebody as trustee under deed of trust made by a legal fiction that looks like it's your name, right? Trustor, and recorded as an instrument, in some office, more fully described, they're under written request to reconvey, and having received from holder of the obligations thereunder, right? So the trustee has received from the holder of the obligation a written request to reconvey. What's that say? Reciting that all sums secured by said deed of trust have been fully paid, and said deed of trust and note or notes secured thereby having been surrendered to said trustee. Who's got the note? Princeton Reconveyance Services, Inc., FKA Princeton. That's a legal fiction too, or that's their full legal name. Does hereby reconvey without warranty to the person or persons legally entitled thereto the estate now held by it thereunder. Witness, therefore, Princeton Reconveyance, Inc., FKA, Princeton Escrow Company, as trustee, has caused its name to hereto be affixed by its vice president thereunto, duly authorized, blah, 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 blah. Hey, they released the mortgage. Well, who was the mortgage for? And you would say it was for you, but they would say no. It was for this legal fiction. This is who made this is the trustor. It's not you in your proper name. It's you as a legal fiction that you haven't claimed. You didn't claim this name. This is the name of a company doing business under a name other than their own. DBA. Right? So you could just as easily do the form, as we'll see in a minute, to claim this name as you did to claim your proper name. Well, and so one thing you might want to do, and I just thought about this the other day, you can go online and you can put in your MIN number on some mere site that, supposed to be able to check on your property or check on your loan, check on your servicer, yeah. Put in the name of the trustor, just as you see it. All caps, the commas, any periods, anything, just exactly as you see it on the deed of trust, instead of putting your name in, and see if something comes up. Well, Gabe had more than one of these in here, because here's another one from a different company, but it's still saying executed by Lazario Gabriel Angelo, a married man, as trustor, dated, file number. And you would see, if we were looking, if I had them laying side by side, that like the county recorder of San Diego County, California. That's what this one says, right? County recorder of San Diego County, California. This one says recorder of San Diego County, California. Right? Just recorder, not county recorder. Or this one said county recorder with the C capitalized. So county recorder should be like the proper title of somebody's office. If it was just lowercase c, county recorder, well, that's different than the person that has this title, county recorder. The lowercase c, county recorder, would actually be the recorder for the de jure territory that's called the county. Because lowercase c county isn't the proper name of something other than it's defining a territory, right? Go look at the definition of county in a dictionary, you get a better idea. That's just the name of a territory. But here it's part of a name, right? It's a proper name. And not that it matters so much on this one, but because it needs to be pointed out, on a lot of your foreclosure paperwork, when they send you stuff that's been notarized, and it's notarized from out of state, well, this doesn't mean a thing unless there is a certificate of authority from the state to go with the seal. And so you could make an issue about that and, get a hold of their state and see if there is one and take it to court and try to make a lot of noise and blah, 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 blah. But instead, what we need to do is claim this frickin' name and say, that's my property. Because this said here that the securities, where's the one? This is it, right? That the note or notes secured thereby having been surrendered to the trustee for cancellation does hereby reconvey without warranty to the person or persons legally entitled thereto. They're supposed to give you back your note. But they took your note and they endorsed it and they deposited it like legal tender. Although it's only good for public debts at this point because it's a commercial bank note. But once they do it, it needs to, if the owner, when the owner shows up, he can claim it on demand, paid to the order of on demand. And I don't know if I'm going to have a note here to look, but on the last page of somebody's note, it has a pay to the order of blank that hasn't been filled out. Well, so they've converted your private note into a security. They securitized it. They did a conversion. Well, technically, that's unlawful. It's called an unlawful conversion. And because they did, and they can't give you back exactly what you gave them, right? They can't give you your note back. It isn't a note anymore. Now it's a commercial bank note instead of being a private note. They have to pay you in legal tender. Good for all debts, public and private. And so you have a payday coming. That's why you're going to want to do this, in my belief. You claim this name here. And if you're in a foreclosure, well, you're going to take it to court. But if you're not in a foreclosure, you take it to the people that say you have the reconveyance and say, okay, here I am. I'm the owner. Give them your certificate. Please send me my note. The reason they're not sending the note is because nobody has claimed the name of the legal fiction. That's the trustor. Okay, I think I beat that one into the ground, right? But that's what's happening. And this one even had another different style of name. This one had him as, this one just had him without the addition behind his name. And this one had him as a married man and his sole and separate property as trustor, right? So from the beginning of the first capitalized letter until they say comma as trustor, that is the DBA that they're saying is the owner or the one who's entitled to whatever is going to be returned by these reconveyances. One note for $608,000. It's a good payday, Gabe. Hope you remember Rob Ryder. I don't have any property. That's why I'm doing this, right? I don't have any property. That's just the way God works. That's a wonderful thing. So for me to ever really get anything, get ahead, I got to help other people do it. And I don't mind doing it. It's good. It's, thank you, Jesus. Thank you for the job. Okay. So let's see what he did because of that. Because I sent it back to him and said, well, you need to claim these names. And so he did. And he went down and he's filled out another one of these, right? Same form he did before where he had put his name. Well, now he's a married man. And this was the other one, right? Lazario, Gabriel, Angulo, a married man and his sole separate property. Just the way he saw him on the papers. And when he went there, the clerk was trying to put this in. And apparently this last one here, there wasn't enough room in the computer for it all to go in. And she said, I can't get all that into the computer. But then she looked at Gabe and said, well, but don't worry. We make a copy of this, right? We scan this. It'll be in the record. So it's like she knew what he was doing, right? And that's huge. So again, did it the same way he did before, right? He's claiming it. Now, I know it looks like he's using all capital letters, but I don't want, I'm not, let's not go there, right? This here is him as a living man, full legal name. This here is him as the name of a business. Why? Well, because this one says put the fictitious business name, and this one says put your registrant information. That's why. This one has San Diego County in. This one doesn't. Does it need to be in there? I don't know. I think it should be. It's like, well, how come my property's in one jurisdiction and I'm not in the same jurisdiction? They have your residence address as being in the improper venue, where this would be the proper venue. And the reason for that is when the county is just a territory, it's just a name. It'd be called San Diego, right? You look at a map, it just says San Diego. It doesn't say San Diego County. I believe. I know in Michigan it doesn't. It just says, it would say San Diego. But that lowercase county, San Diego, has a corporate body politic that is a political subdivision of the sovereign state. That is called San Diego County. Its jurisdiction is within the boundaries of County of San Diego, with the C being lowercase. Common, county, territory, San Diego. But what they use is they'll use, at least here in Michigan, they'll say instead of San Diego County, they'll say County of San Diego. Other places may just capitalize the San Diego instead of having it proper case. It's just that they're different venues. And so it's easy to see here in Michigan because of the two different ways they use it in the name of something, of a county. Okay, so hey, he put this in, and now it has to be, he put it on 1019. No, that's what he put it in. What am I saying? When did this go? July 17th. Hey, it was just last week, right? 3-4 weeks, boom, it'll be done. You know, but I believe now he could take this, say, look, I claimed it. You know, there's nothing that he's in a foreclosure. So my thought at the time was, well, we'll just take these and we'll send them to the foreclosing company. But now thinking about it, no, Lazario or Gabe, we should be mailing these to who's ever saying that they've released the lien and ask them to send you back your notes. As the Reconveyance says that you can. Take a copy of the Reconveyance, a copy of this, send it to them and say, please send me my property. Let's see how that works. Let's not wait till it's in, right? Just do it now and, well, see what happens. Outstanding. Okay, so that's why you claim the name. It's really that simple. Well, let's look at a few more. So how do you do all this? Oh, just real quick, just to show some other, because this lady had a title insurance paperwork. So what names do you want to claim? Let's go there. I think you want to claim the one on the mortgage or deed of trust, the trustor, the borrower, whatever they call it, that person. Do you want to claim the name that's on the warranty deed or whatever you want to call that? Warranty deed, trust deed, security deed, right? Or you're the grantee, so the name of the grantee. And you want to claim the name of deed of trust, mortgage, on the title insurance, which is this one. So on, everybody had title insurance of some kind. This is some title service, but it's through Chicago Title. And you're looking for the Schedule A to your title insurance, because on there it's going to tell you who is the insured, right? And so this name here, you're going to want to claim. Why? Because your interest in land is in fee simple. This person has fee simple title. And as soon as you claim that as your property, you have fee simple title. And so you need to claim the name on your Schedule A of your title insurance policy. Just the way you see it, right? If this is lowercase, do it lowercase. If you see another one where it's uppercase, well, then do two of them. Do it the way you see the name, exactly the way you see the name. If it has periods after the L's, put them after the initial. If it doesn't, don't. Just do it the way you see the name. If you need to do more than one, well, that's just the way it is. Claim the name. Every jot and tittle of the laws. This is where the devil is. The devil is in the details, right? And a comma is a detail. So is a period. So is uppercase compared to lowercase, because she has other papers where husband and wife are capitalized. In fact, I think it's on her warranty deed, right? So, but this is who the title insurance company says they insured it into, and they guarantee them freaking free simple titles. Claim it. Let's see what this one was. Because she had a satisfaction of mortgage in her case too that we're working on. Rotate, rotate. Who's this one? Right, here's her satisfaction of mortgage. See here, it's uppercase. So do two of them. Norm and Al with a period. This one's got periods. The title insurance didn't have periods. This one has periods. What are you going to do? You're going to do two of them. You'll do one for every freaking style of name you have because you're going to claim this. They got to give you back your damn property. The undersigned bank certifies and acknowledges the following mortgage is fully paid and satisfied. Fully paid and satisfied. Fully paid and satisfied. Mortgage executed by this legal fiction name to bank and recorded in wherever it is, which conveys or covers the real estate and the following legal description. You have satisfied the mortgage. So how could they foreclose on you? Yeah, you're getting the picture, right, people? Oh, somebody's jumping up and down and having a great day because it's like, wow, that's huge. That is huge. Who's the name of the borrower? Right? Mortgage. Norman L. Gould Sr. and Jillian B. Gould, husband and wife. I don't think they had senior before. Put it in. Do one. If it costs $15, just do it. Just do it. Whatever the name is, because the borrower on the mortgage is actually the investor of an investment contract. And I'll just have to put the link in to the videos I did in the past where I'm reading a letter from a guy who had sent, he was a paralegal working for real estate or foreclosure attorneys and defense attorneys in Florida who wrote to the 50 attorney generals of the United States and explained to them what was going on. So I believe he believes he's correct. And he said that the borrower is the investor of an investment contract and that there's actually documents that show that it's your property. Right? But what they're doing is they're putting it in the name of a legal fiction, not in your name. And so it's always, well, what's the name they're using? Oh, hey, they're using these names. Oh, warranty deed. Just to look at a warranty deed. How come all these are upside down? Jeepers, man. Right on here, it's lowercase. So it's been uppercase on one, lowercase on another. This one's got periods. The other ones don't. Right? Just do it. So that's mine. That one's mine. Yeah, I claim that one too. Yeah, that looks just like mine. I got one just like that, except it don't have periods. I'm claiming that one too. It's almost a match set. Claim them all. Okay. Now. What else did I want to show? Assume names. Okay. What was this? Right? They may call it a trade name. Right? Arizona trade name application. And in this case, I know people have tried it and they wouldn't let them do it with just their name. But if you wanted to do it with your name, right? Because I really think we do want to claim our name, but we want to also claim these other legal fictions that put a semicolon and put estate after the name, and that's your trade name, right? So here they call them trade names. In Michigan, they call it a business registration certificate, person conducting business under an assumed name or partnership. Right? Name of business, address. Name of the owner, address. Yada, yada, yada. Now, this is where the strange stuff is. See, here it is, County of Kent, State of Michigan. This is why I didn't do it at the time, because that's not the proper place. It's like, well, I don't want to do it there. But if it's a parallel jurisdiction that has a right to be there, and I want to do business there, then, well, maybe I do need to do it. But it's the filing fees. It's where do you file it at? And if you file it in your county, then where you want to be, then you wouldn't want to do it in the county of Kent. You'd want to do it in Kent County. I say all this just to show. So here in Michigan, the person that I think is the county clerk, right, the one that was elected, Kent County elected county clerk, is this lady named Lisa Posthumus Lyons. But she says she's the clerk of the county of Kent and the circuit court thereof. She didn't say she's the clerk of Kent County. She says she's the clerk of the county of Kent. Therefore, do hereby certify the foregoing true and exact copy of the original document on file in the office of the county clerk. Right? She didn't say anywhere in here that she's the county clerk. She's the clerk of the county of Kent. Well, then who the hell's the county clerk? I think the county clerk is actually a guy that we would call the county administrator. There's a guy called the Kent County Administrator. Well, administration is being a clerk, right? Ha ha, change the name, change the word, use a synonym. It means the same thing. It ain't her, because she says she just certified, she swore under oath that she's the clerk of the county of Kent. And this county clerk is not the same as her, and her sign is an uppercase that says county clerk. She's not the same one, right? She says she's the Kent County clerk. But she didn't say she's the Kent County clerk. Because Kent County is the name of an entity, and county clerk is an office. Right? So Kent County clerk is not the same as saying that she's the Kent County clerk. But nevertheless, hey, do the form, claim the damn property, right? I guess we could do that. If they won't let you put the name, then you can put comma state. But I think what I'm going to try to do is do this and take it to Kent County Administrator as the county clerk and tell him I want to do it there. I want to file in his office. Because this shit here in the bottom, this is just saying that there's a copy in her office. It didn't say that she has the original. That's this part up here. And this you're supposed to send to the county clerk, who I believe, again, is the Kent County Administrator. And the reason you have to do it, this is just how simple it is for me. This is the law for Michigan that goes with doing that damn form. A person shall not carry on, conduct, or transact business in this state. So it didn't say the county, it's lowercase state, under an assumed name or under a designation, name, or style other than the real name of the persons owning, conducting, or transacting a business. So unless we can get somebody to tell us what is the definition of real name, right? Then I'm going to say the style, because one's in uppercase and one's in proper case, the style is different, so I need to do it. But I don't want to do it in the county of Kent. I want to do it in Kent County, because that's the proper jurisdiction for me to be in the state and not in the King George III's jurisdiction under county of Kent. So there you are. But one thing I had never thought of before, and having had to go look at this again, if you have a sole proprietorship, which I'm going to say that's what your all caps is, it's your sole proprietorship. Well, you need to register it as a business and pay business taxes with your Department of Treasury or Revenue. And so we want to fill this form out too. So I'll just go back to the beginning, right? This is for Michigan business taxes registration booklet. So, just go to state sole proprietorship business taxes and see if you find something that takes you to your state where you find something that tells you how to register your company. And that's what this thing is for. And so because we've never registered our company, our all caps, with the Department of Treasury, we're not getting the fucking mail. And this one doesn't cost, I don't think this one costs anything to do, but it's a little bit more detailed to fill out. Determine your structure. Well, okay, like I said, I believe it's I'm either an LLC, limited liability company, or I'm a sole proprietorship. And I believe I may have been an LLC as a child so that I could have other people involved in my business, because the business is established when you're a child, but it becomes a sole proprietorship when you become an adult. But depending on your legal structure chosen, business may have been registered with the local county clerk's office or the state of Michigan. Sole proprietorships and co-partnerships should contact county clerk's office. Again, not the county of Kent, Kent County, county clerk's office, Kent County administrator. Do not complete this registration form if you wish to apply for an ID for your bank account. Use your Social Security number for this purpose. I don't know why I highlighted that. I'm just going through things and looking at things that were why. And this is the instructions, because eventually we're going to get to where we're going to fill the form out. A sole proprietorship with no employees does not need an FEIN to register for Michigan business taxes. Good. You don't need to go get an EIN number. Line 2, they want the company name. If your business is a sole proprietorship, enter the owner's name here and the business's name on line 3. Legal address, physical address. Enter the physical address and the actual location of your business. So I think anytime it says physical address, you want to put in Kent County or, whatever the name of your county is, not County of Kent. Kent County, San Diego County. The name first, county second. Both proper case to show that it is the body, corporate body, politic, legal, or political subdivision of the sovereign state, which means it administers the state laws within its territorial boundaries. Physical address, then you got to pick what type you are, sole proprietorship, limited proprietorship, or LLC. Not really sure. Pick your business code. Okay, so now we get to the form, right? And all right, don't need an FIN, it said, so I just crossed through that. I'm supposed to put my Robert Allen Ritlewski here. Business name, well, Robert Allen Ritlewski here. Address. Pick what kind I am. Enter my SIC code. I got to pick you got to pick the tax it's going to be. So use tax would be one of them for sure. Well, I put sales tax even. I don't know. Income withholding. Single business tax required only if annual gross receipts in Michigan exceed $350,000. Right, so I don't know which ones of these I'll do yet, but yeah. Yep. Check. Fill in the blanks. Do what it says. Yep. I only have one problem. I don't have a driver's license, so I can't do this necessarily, but I'm going to try it without it. Complete the form for each owner. Attach separate lists as necessary, right? Now here, it has name, and they want you to put last, first, middle, and I'm not going to do it. I'm going to cross that fucking shit out and put Robert Allen Ritlewski. Title, owner. Right? Sole owner. Rightful proprietor. Son of God. Pick something. Put your social security number in. Claim it. Put your driver's license in. Claim it. Put your date of birth in. Claim it. It's all yours. Mine. You can't use it. But hey, if I have questions, I got a phone number. So, this is next week's work. But, right, this is in addition to doing at the county clerk what needs to be done. You need to register your sole proprietorship with the state. And it's going to be the same, I'm sure, with every state. right? And this is why we're not getting the mail about things happening to our account, because they don't know it's ours. We haven't claimed it. So just a couple more to show that in Wisconsin, what you do is you register for a trademark. Hey, that was what you did in um, Arizona. Okay, right here, exact name or phrase to be registered. What did it say? It said exact, E-X-A-C-T, name or phrase to be registered. It said name. What's the name? The name that's on the grantee, the grantor, the trustee, the trustor. No, you don't put that on there. You put just the name, right? Whatever they said it was on your deed of trust, on your mortgage, on your warranty deed, on your title insurance, as the case may be. But, so that was the simple one. And this is the one that you do with the state, right? State, Wisconsin business tax registration. You have to do this one also. And so this one for sure you want to do on your all caps name. Whether we need to do it for all these other entities, I'm not really sure, but you certainly want to do it for your all caps name. Well, that was simple enough. Okay. So that's the idea with the claim the name. Just to really quickly show you, another guy was able to do one in Texas. I don't know if he ever used it for the same thing, but he went in and he put his first, middle, last name, his address, said that was the business. It was a sole proprietorship. Put his name, said he was the owner, right? All of this is the same, address the same, name the same, everything the same. Printed name of the owner. Well, I told you I was. I'll tell you again, I am the owner, right? Signature of the owner. Owner. Hey, we're talking about this guy. He's the owner. And the frickin' state of Texas agrees with him. So now do the same thing with the names on the deeds of trust, mortgages, title insurance, warranty deeds, security deeds. Claim them. Tell them they're yours. And then if you find that you have a reconveyance, send it in. Contact the title insurance company and say, hey, you never did give me my fee simple title. Here's the evidence I'm the owner of it. Give me my freaking title. We just got to try these things and see what they do. I don't know what they're going to do. Let's find out. Okay, so I wanted to show you a couple other things that had happened. Going back to the beginning about the things with the judges, right? That what we had done. So our witness, with her information to this judge or to this court, that we just kind of took off pieces of paper that we had that showed what was going on. We wrote a letter to the civil supervising judge and said, notice of deprivation of rights under color of law, prosecution in improper venue, case whatever, petition for discharge, request exhibits be identified by the court. Right? That's what we told this civil supervising judge that we'd like to happen. I, sui juris and real party and interest, petition the Los Angeles Superior Court to discharge case and any others incorporated by reference. I believe the plaintiff's attorney of record is an officer of the court who is prosecuting this matter in an improper venue, Superior Court of California, County of Los Angeles, for a plaintiff using a false identity and against a Jane Doe defendant causing a deprivation of my rights under color of law. I believe the plaintiff's attorney of record is in contempt of court, violating the Constitution of the United States, 18 U.S.C. 242, and the law of God. I ask Los Angeles Superior Court discharge case and provide me a complete, legal, and equitable relief the court deems just. I include with this petition a common copy of the summons and complaint that evidences the different names of courts for different venues and asks they be identified as exhibits of evidence in the official court record. I have read the foregoing petition and know the contents thereof. The same is true of my knowledge, except those matters which are therein stated on information and belief, and those matters I believe to be true. I think I found that in California where this came from. This is their signature verification statement that they use. Executed on some day, Los Angeles County, California, not County of Los Angeles County. Right? And this here says that this was brought into the County of Los Angeles. Right? So that's the wrong venue for the witness. I declare in a penalty of perjury the foregoing is true and correct. Okay, and so what this had, right? So this is the summons for this case. And the summons says the name and address of the court is Los Angeles Superior Court Central. And this is the complaint that says it's Superior Court of California, County of Los Angeles. That's got the same street address, right? Superior Court of California, County of Los Angeles. Where this one said Los Angeles Superior Court Central. So you have a summons for one court and a complaint for another. Yeah, I know it doesn't make any sense. That's the idea. It doesn't make any sense. They're doing it wrong. This can't be the proper venue. We wouldn't do shit like this. All right, this is somebody trying to take advantage of me. And you're supposed to treat your brother like you treat yourself. So I must be in the Judeo side of the Judeo-Christian divide when I'm going into this system here under Talmudic law. That's one venue, and right, the laws of Jesus are the other venue. If you want to get out of one, you need to tell them that's an improper venue for me. Right? This is probably the proper venue, Los Angeles Superior Court Central. That's where we would want to go to give a affidavit of probable cause that, we need to have an arrest warrant issued or something. I'm guessing. That's something else we're working on. How to actually just go and give probable cause affidavit and have an arrest warrant issued because these people are depriving us of deprivation of rights under color of law in violation of 18 U.S.C. 242, which is a federal law, which they do have to enforce. And it's like, a couple weeks ago in the last video I did, I said the same guy that just has now gotten the judge to say, yeah, we're going to hear that and have a case on the 31st of July. And that particular hearing a few weeks ago, I had asked the judge, Judge, I asked you last time I was here, what's the significance of the gold fringe flag? And you said that the federal law applies here, but you didn't tell me what that is, right? Does that mean like a United States Code? Like Title 18? Yeah, United States Code. Well, how about the Constitution of the United States? Yeah, that too. Well, how about the Constitution of Illinois? Well, that's subservient or under the Constitution of United States, but where they agree, yeah. If not, well, then the Constitution of the United States supersedes the Constitution of Illinois. I don't know if his answer was quite that long, but you get the point. The guy said, if there's a gold fringe flag there, the federal law applies. Well, 18 U.S.C. 242 is a federal law. And so you just tell them, you got a gold fringe flag, that's a federal law, you have to enforce it. I accept your oath, bind you to it, remind you of a fiduciary duty. And again, the flag with a gold fringe is an Army flag. It's called the national color. Look in Army Regulation, AR 840-10, I believe it is. I did videos on it, but I don't know if I can tell you where it is. And I'll tell you in there it is. So I don't care if somebody else has an amity flag. Well, that ain't what the fucking book says. I'm going with the book. Right? I'm going with the procedure. I'm going to go with what it says they have to do and audit what they do by their procedure. And if they don't do it, say, well, you're depriving me of my rights then. I want to file for a probable cause for an arrest warrant. Have your ass arrested. But not necessarily the counter troll, the person at the top of the food chain that has the counter troll down there. So like the Secretary of State, or, well, I'll show you what I did. I just wanted to see if I could do this. I filled out an incident report. Hey, I found out I went on my sheriff's website, and you can put incident reports on online. This incident has been reported to the Kent County Sheriff's Department and is pending approval. It was a suspicious situation. Now, here's one of those things where I didn't have any choice. It just filled in the blocks, but it didn't have a place for middle name. It just had a place for first name and last name. So I put my first name in, and now the way they put this on there is exactly the way it shows up on a certified copy of record of birth I have. My address, my employer, that's Jesus Christ, that's what I'm working for. Where the incident was, this is actually the Capitol building. And my narrative. In a manual for court reporters and recorders published by the State Court Administrative Office, Lansing, Michigan, is stated that court recorders have not been appointed by the governor since 1990 AD. Michigan Compiled Law, MCL 600-1104, aka Section 104 of Act 236, 1961, states in part, and it does, every reporter or recorder shall be appointed by the governor. Well, how can the law say they shall be appointed by the governor and the governor hasn't appointed any recorders since 1990? That would mean there's no recorders for the court. Well, I would believe that's a deprivation of rights under color of law. Hey, the individual known as Rick Snyder, claiming to be the governor of the state of Michigan, and the judges of the courts are in contempt of the people of the state of Michigan. Why? Well, because we passed a frickin' law that said every reporter or recorder shall be appointed by the governor. They don't have a fucking choice. Just do it. And are engaged in deprivation of rights under color of law because they didn't, which means they're violating 18 U.S.C. 242, the Labor Code, the penal laws, the common law, the Constitution of the United States, and the law of God. I swear to it. Please investigate for the sake of my grandchildren and your kin. Both the manual for court reporters and recorders and Michigan Compiled Law are available online. Feel free to contact me if you need any help finding them. Subsequent to that, because I just did this a few days ago, I got a response back that whoever the deputy was that looked at this said that it was inappropriate, and they weren't going to. It was inappropriate for the inappropriate. I should go find the email, but I ain't worried about it. So I responded back to her and said, well, I don't believe you have the authority to tell me that, and I need to see your certificate from the, its acronym is called MCOLS, but they're the ones that certify that people are actually law enforcement officers. And they, guess what? They issue them a certificate that says you're a law enforcement officer. So I need to see a copy of your certificate that says you're a law enforcement officer. And so while you're getting me that, take my stuff to the sheriff. And yada yada. So now that was on Friday. It was actually in the evening, so we'll see what Monday brings. We'll see what the phone rings. What else did I want to show? Because I had these things here. And they're just, it just shows this is why you do things. To get somebody to answer to see what they say. Okay, this is another example of a title insurance, Schedule A, where it says the name of the insured is Robert B. Kirby and Barbara Haggerty, right? But then it says title to the estate or interest in the land is vested in, and it gives us long-ass legal fiction, right? Well, I'm going to do two of them and say, okay, I'm the insured, so I'm going to do this one. And I'm going to do this one because this is the one that the property is entitled to. And once you claim that name, well, you have fee simple title. Simply amazing. They're going to want to argue it, but, I'm going to say, well, that's what it says. And I'm going to quit blaming the judges because, see, the judges, while they're not clean, right, the ones that are really causing the fucking problem are the clerk's office. because they never do proper service. They're the ones that are supposed to send you stuff for the court. So if they send you a summons for one court and a complaint for another, that's the clerk's office that did that. I'd complain to the judge. If you're not getting the papers, oh man, I wish I could find that. In fact, I'm going to have to. I sent a dude down because we looked on his docket entries and they had sent some motion out. Said, well, did you get a copy? No, we'll go down and get it. Well, he goes down there to find out why he didn't get a copy, and they go to the file and they pull out an envelope that has a sticker, a file stamp showing that it had been put back into the record, right? So it had been mailed, came back to them, and was put back in the record. And on the envelope is a sticker from the post office saying they couldn't deliver it for whatever reason. That's why I had to find it exactly. But inside there, because it was a windowed envelope, they had put the paperwork backwards so no frickin' address showed up. That's why they have windowed envelopes. So they can put paper in backwards and no address will show up. Otherwise, the address would be on the envelope. Right? So in your frickin' file is all this mail that you never got in the clerk's file, filed in the clerk's office. In fact, let me go find that. That's just too good not to share now that I'm thinking about it. So hang on a second. Okay, so what we have here is he went down to get this this envelope, or to find out why he hadn't gotten his copy of the motion. And what's this say here? Something court filed 17 May. And this was May 10th, right? So it went out May 10th, came back, I don't know, either 17 May or May 22nd, whichever one. Oh, May 22nd, 2017, May 22nd. They filed it back in their court. Why? Return to sender, attempted, not known, unable to forward. Why? Because here's a window, and in the window, they had the paper backwards, so it was fucking blank. So they couldn't send it to anybody. Although, so there's what was in the thing. And although I can't see how it was addressed necessarily, but right, there's a copy of the motion that was supposed to have been sent, but they purposely put it into the envelope backwards or without an address on it, so it doesn't show up. That's how sneaky they are, right? It isn't difficult. They lie, cheat, and steal. That's how they cheat. But this was in the guy's file, right? So if you haven't gotten stuff, if you were to go to the court, start complaining, you may find it in there. All right. I wanted to go back to this because, okay, this was this is the letter that we did, and I just wanted to show the response. So we wrote that letter, and the judge was nice enough to respond. And she responded on bond paper, the Superior Court, Stanley Moss Courthouse, Civil Division, under the seal, Superior Court of California, County of Los Angeles. Now, because it's in all caps, right, County of Los Angeles could be Los Angeles County. And it's a trade name or something. I don't know how they do this stuff, but not that I care. She's the judge of County of Los Angeles. Okay, well, it's happening in her court. So this paper is under the seal of her court. Right? So our witness, Letty, I acknowledge receipt of your letter in this office on July 10th, 2017. As your complaint concerns a civil matter at the Stanley Moss Courthouse, I will investigate the issues raised in your letter and respond to you. This review process may take approximately 90 days to complete, and you should expect to receive a response within that time period. Sincerely, Supervising Judge, Civil Departments. Right? Now, why did she call it a civil matter? Because this is the second time that this happened to Rosita in Illinois, where we were trying to point something out at the prosecutor's office. And the prosecutor said, well, that sounds like a civil matter to me. What that means is right? It is a civil matter. They're violating your civil rights, civil liberties, right? That kind of civil. And the only one that can violate your civil rights is the government. Other people can commit crimes on you, steal your property, commit homicide, and so forth. But the only one that can violate your civil rights is the government, or those pretending to be the government. So it is a civil matter, lowercase civil matter, not the uppercase civil court, right? Lowercase. It's a matter with the government. And this woman, this lady, this judge, has superintending control because she's the supervising judge over the Stanley Moss Courthouse. And as your complaint concerns a civil matter at the Stanley Moss Courthouse, I will investigate the issues raised by your letter and respond to you. Amen. And what were we talking about? I believe the plaintiff's attorney of record is in contempt of court, violating the Constitution of the United States. 18 U.S.C. 242, the law of God, and I ask Los Angeles Superior Court to discharge the case. Provide me a complete remedy, a complete legal and equitable relief as the court deems just. Words to that effect. Okay. So we'll see where that leads. But, quit blaming the judge. Use them, right? Blame the clerk. And blame the judge. Or tell the judge you're blaming the clerk. Tell the judge you're blaming the attorney. Tell them, right, they're not following the law. And point out a federal law and say, hey, you got gold fringe flags. That means the federal law applies in your court. Or, it's a war trophy and you're an insurgent, in which case I'll have to call the Army and have you rounded up. Okay, and then one last one that, well, maybe more than one. I don't know what I got here. I wanted to show this book because this is, this is the gentleman in New Jersey, Claude is his name, that went to put a motion in. They said, well, you got to put that in at the foreclosure office or something like that. It's $50. He couldn't go. He sent somebody down. They did it. They didn't get a receipt. And he told me, I said, well, Claude, you got to have a receipt. I mean, how else are you going to be able to say that you actually did it? Right? So he went the next day to get one, and they said, well, we don't give it. We don't give receipts if you pay by check. Your check is your receipt. Well, that isn't the way it's worked. All of these fees are tied to accounts, right? And so to do the proper accounting, they have to give you a freaking receipt or they can't do the accounting that shows that it went into that account. And they didn't do that, which means it didn't go into that account. And so, hey, what's going on? So he complained to the clerk, and they are refunding him his fee, and they sent this manual, how to file a motion in a foreclosure case before a judge. Superior Court of New Jersey, Chancery Division, General Equity. Well, that isn't the court they were taking him to. They were taking him to, here's the summons, Superior Court of New Jersey, Chancery Division, Mercer County. But there wasn't any, there was nothing on there about it being general equity. Right, so it wasn't going to the right division. Complete the forms are submitted, and this tells you where to submit them. And so, first of all, it looks like this came out of some kind of book, right? So I want to know what else is in this book that has all this information for Chancery General Equity, because if they have one on how to file in a foreclosure case before a judge, then they have to have one on how to file for probable cause to have an arrest warrant or whatever I need. And because I see these lines here, it's like, is this in a book? Are these just pages laying out of a loose leaf book or what? But, Claude, ask them what else they have. You should use this packet if you want to ask for specific release or ordering during a course of your foreclosure lawsuit. Any party to a case may submit a motion. The person submitting the motion is called the moving party. The packet explains how to file a motion directly with the judge in the county where your case is filed. The list shows some examples of motions filed before a judge. However, please note this is not all inclusive. Motion to vacate, motion to vacate, motion to vacate, motion to amend. How about motion to discharge and give me back my property? How about motion to for an issue to show cause why the plaintiff's attorney of record should not be found in contempt of court and in violation 18 U.S.C. 242, deprivation of rights under color of law, for prosecuting this in an improper venue using a false identity and improper court documents. Right? You can motion whatever you want. All foreclosure documents must be filed at the administrative office of the courts. Right? So this says where you're supposed to file them. This is what says where you're supposed to submit it, and it's not quite the same name. So we got to make a phone call and say, okay, why does this say to submit them here? But this says to file them here. It's got the same P.O. box, although this doesn't have the dots, but it has a different title to where it's supposed to go to. So who the fuck am I mailing them to? Foreclosure documents taken to the county for filing will not be accepted for filing. Foreclosure documents taken to the county for filing will not be accepted for filing. You have to file them with the administrative office of the courts. Right, so this is, I haven't really had a chance to read it all, but this is like step by step, everything you need to do. Start at the beginning, go to the end. Filing fee, $50 in the form of a check, money order made payable to Treasury, State of New Jersey. Okay, mail your stuff, do whatever you're supposed to, fill out the forms. Superior Court of New Jersey, Chancery Division, right? Blank County. See, now all this, right? All this is improper case. Let's look at that other one real quick. All this is an uppercase. And it doesn't say on here anywhere about general equity. And the other thing is, this is supposed to be a summons, right? But there's no file stamp on it. It wasn't filed in the court. Right? I said you got to file this stuff. Oh, just said it in this other one. Right? All foreclosure documents must be filed at the administrative office of the courts. Superior Court Clerk's Office, P.O. Box, Trenton, New Jersey. Okay. Well, this one wasn't. And this is what the guy is being foreclosed on. It must be a different venue. I think it's improper venue. See how easy that is? Right? You just say it is. And then you say, well, Judge, I don't need to prove it. They need to prove they're in the proper venue, and you need to make a legal determination. Right? Or it's a deprivation of rights under color of law in violation 18 U.S.C. 242. And I'm going to have to go apply for an arrest warrant. Now, what I would do, because nobody wants to be the defendant, right? But these want you got to say who you are. And if you look at the names, when they do the defendants on foreclosure, they have whatever it is, like it's not really your name, but then it has et al. Or whatever those letters are afterwards. So it's all inclusive. It's anybody who might be a defendant. So what you want to do is you want to put your proper name as the defendant, not the legal fiction. When you're filing this paperwork this is my belief. I haven't done it, but I believe that's what we're supposed to do. Because here it says I, right? And you're going to put your full legal name and the defendant in the above captioned manner. Well, if that's the case, then you got to be the defendant. Or no, I take that back. You just put it the way it is on the paper for the case. But you put here, right, because it's et al, so it's for all of them. Well, now you're just one of them defendants, because this is for numerous defendants, the et al. So I guess I would do this part just the way it is on the case, and I would put here now, I, in my full legal name, and the defendant above caption matter. I make this certification to support my motion 2, and you're supposed to write in what it is. Hey, you'd have to read all of the instructions to know what to do, but that's what we'll do next week. I certify these statements are true and correct. Outstanding. And so I've looked at this a little bit because I didn't get this until Friday, right? So I haven't really had much time to look at it. But what I noticed is that when you get down to this thing, because this is supposed to be how you file a motion before a judge, there's really nothing called a motion, right? You got notices and certifications, but the motion is actually an order because it's an order to move the court. So what you're giving them is the order that you want the court to determine or make a decision on. And they're going to set a date to decide. And in that time, well, the other side has to complain about your wanting this order. And if they can't complain to the degree that the judge agrees, then he'll issue the order. All right, so this is huge, man. So I don't know how to tell you to find this for your own state. I'm just saying, look at this, right? How to file a motion in a foreclosure case before a judge. And one way to do it would be to write the judge and say, Judge, I don't know that I'm getting proper service from the court's office. Is there a procedure for me to lay before you a motion for my foreclosure case so that you see it as, as an exhibit in the court case? And see if they answer you. Because if you haven't noticed, the judges are giving legal advice to these people who are asking them questions. And it's damn good legal advice, and you should take it and say, okay, he's not the one lying, right? I'm in the improper venue. He's judging by the venue. If I don't say it's the improper venue, then he has to judge by the laws of that venue, its jurisdiction. And in that venue of King George III and his successors, you don't have any frickin' rights. You're a subject. So you need to say, hey, this isn't the proper venue for me. And now they're going to want you to they may, because this just happened to a guy in Iowa, because he called me and did this. And then the judge said, well, what do you mean by the venue? And then he tried to explain, and the judge rolled by it and so forth. But interesting in that case, too, he had written the chief judge, just like the lady did, that got the letter from the judge. He got one, said they weren't going to get involved, right? That he couldn't do an ex parte motion. We had asked for ex parte motion, said they couldn't do that. But when he went to court, there wasn't anybody in the courtroom. One other person, the judge. I don't think there was a recorder or anybody there, and there wasn't a bailiff, but there was a dude standing back by the door. And so he said, this is different than, any court I've been in before. And, she's asking these questions, and they ended up finding him guilty. But she asked him what about the venue, and I don't remember what his answer was. But my answer to that is, Judge, I don't need to tell you what that means. I need to, as the defendant, I need to challenge venue. That's in Federal Rules of Civil Procedure, Rule 12. Right? I just need to challenge the venue. Once I challenge the venue, I believe the plaintiff, prosecutor, needs to prove it's in the proper venue, and that you need to make a legal determination. That's your answer to that. You don't need to know what it is. But technically, what the venue is, it's the county or the district, lowercase county, lowercase district. And if we're supposed to be in this, in a sovereign state, then it would be C for county, not D for district, because district would go with the federal territories, and the county would go with the state as a state. And so it's county, lowercase county of Kent, which its body corporate, body politic, political subdivision is called Kent County, not County of Kent with capital C. See how that works? Okay, I'm going to leave it at that, but we'll have more soon, I'm sure. But what I wanted to do was to say, right, that you need to claim those names. Now, where's the one I want to look at? Look at Gabe's. Right? So go to your property file, whether you're in foreclosure or not, whatever your status is. If you're an owner, go to the property file and look at, tell me you want to see the entire file. You don't want to ask for a particular piece of paper. You just like to see everything in the file, right? And see if you have some kind of conveyance in there. Okay? If you do, well, then whatever name's on there is who you're going to claim it from. And whatever name is up here is the name of the people that said it's yours, right? So Lazario, Gabriel, Angelo, Angulo, a married man. That's the name of a legal fiction. Going to claim it. And once you're claimed it, well, you're going to say, okay, hey, I own that. You said it's free and clear. Give me back my freaking notes. Yeah, what is this one that says about the notes? Yeah. And having received from holder of the obligations thereunder a written request to reconvey, reciting that all sums secured by said deed of trust had been paid, and the deed of trust and the note or notes secured thereby having been surrendered to the said trustee for cancellation, does hereby reconvey without warranty to the person or persons legally entitled thereto. But they deposited your note. They converted it from a private promissory note to a commercial bank note, and they can't make it a private promissory note again, so they have to pay you in legal tender. It's value. It's a wonderful day. I wouldn't waste any time. Be the first one on your block. To own your home, get your fee simple title, and that's the other one. Now, how you get that from the title insurance company, I don't know. You got to find your title insurance paperwork. If you can't find your title insurance paperwork, you're going to have to find your title insurance paperwork. That's all I can tell you. Find out who the title insurance company was on the transaction, and see who it was titled to. Right? Whose freaking name did they put it in? I mean, this is difficult. It's like, okay, well, what name did you put it in? Well, let's take a look at Schedule A. Hey, man, you said that you put this stuff in. You insured it to this guy. Okay, well, I'll claim that one. And you entitled it to this guy. Okay, I'll claim that one too. Which was a little different than this one where, in this particular case, it was just, one. Name of the insured. Your interest in the land covered by the policy is fee simple. Well, then give me my title deed. I don't want a warranty deed anymore. I'll take my title deed. Thank you very much. And then you won't have to pay any more taxes, right? Because, well, you all have it in fee simple. Okay, I'm sure this is quite long enough, so let's leave it at that. And if you can, please do donate. I do need some help. And because until this stuff works, I got to keep picking away at it. Pick. So PayPal, AshleyRitluski@gmail.com. That is the account. Or snail mail to myself. Today's the 23rd, and I got to pay rent in 7 days, and I could use your help. So please do. And next, we'll be going back to looking at getting these arrest warrants for people that have criminal cases or any kind of cases and say, hey, the prosecutor is using a fictitious name and bringing these cases in an improper venue, and he's an officer of the court. That means he's in contempt of court. So discharge the matter, right? They're not taking you to a state court. They're taking you to Judge Judy. And if you agree to Judge Judy's decision, ruling, then they can enter that into the proper court as a foreign judgment. And so you got to say, hey, Judge Judy, I'm not supposed to be here. I'm sorry, this isn't the proper venue for me. Very good. You all have a great day. And God bless. See ya.